And so until they get back into court, I want to bring in my panel, my legal panel, Chinwe Foster and Ben Sessions, to discuss all of this. Thank you guys for standing by with me this morning. There's a lot going on. Obviously, we're still covering the Nelson trial in Florida. And of course, y'all know about the jury note. And so while they're resolving that issue, I want to talk to you guys about what's happening in Georgia. All right, so what are your thoughts about this morning? The state is expected to arrest. They just finished up their last witness, which was Detective Chad Britton. He was the arresting officer. What did you think overall about that witness? Let me start there, Chinwe.
I think that witness really didn't get across. I think I would have hoped that the state, that their last witness would be someone that would kind of bring it all together.
Yeah.
And I don't think that Detective Britton really did that. I mean, he kind of went over Terrell's testimony, but in a way, maybe the state is trying to have Terrell's testimony through the video and through the audio be their last witness in a sense. But then again, the audio wasn't very clear.
Well, I'm surprised that the state is going to arrest Ben, because we heard a lot about a Detective Stoddard, and Detective Britton was asked about a lot of the things that detective had conversations with the defendant. And so why don't you bring him in for more clarification? That would raise an issue as a juror in my mind. Why are you not giving us the entire picture?
I completely agree with you. You would always want to end your case on an extremely strong note. You want to leave the jury with the impression that, hey, this is sort of the climax of our case.
Yeah.
And you want to end on that very strong evidence. I thought that Detective Britton actually was very helpful for the defendant. The issues that were raised on cross were very strong. They showed some real issues as to a conflict in the evidence. And I thought that the points that were made with regard to the defendant being cooperative with him in the course of the investigation, the way that he engaged in the reenactment, the way that he described him having prior incidents with following, all of those facts were very helpful to him.
And the detective also, when you say he was helpful for the defense, I'd agree, because a lot of times his answer was, well, if you say so. This person really wasn't aware of what was going on in terms of, again, that other Detective Stoddard with, Landon Terrell. And so he didn't know a whole lot, so you could pretty much pull him in whatever direction you wanted.
It's really dangerous, though, because in the course of the jury instructions, the judge is going to tell them, obviously, the questions that are asked from lawyers are not evidence. And whenever he's giving an answer that says, well, if you say so, that's really a non-responsive answer.
Yeah,
It really is not helping you. So I wish that he had, in the course of that cross-examination, said, well, hold on, this is really important. Let's replay that segment of the video and nail him down to say, you're not wiggling around on me on this.
So he had a missed opportunity, Chinwe?
Definitely, I agree with Ben. I think that the defense attorney in this instance could have really attacked the officer a little bit more. This is a murder case. This is Mr. Bennett is dead, and this is someone's life that we're talking about, Landon Terrell. And you're just like, well, if I say so. I think the defense attorney really did miss that opportunity to really make the detective, look worse to the jury.
Yeah. Okay, let's go back to the audio, because a large part of this, the state played this reenactment video. The sound was horrible. You had the audio that was played this morning between Detective Britton and Landon Terrell, and that audio is horrible. I mean, you had a jury send a note to the court to say, we can't understand this. And it's so incredibly frustrating, especially with me being a former defense attorney. You had 2 years, state, to get all your evidence together. And for you to present this now poses one of two issues. So you have this audio that the jury can't understand. So basically you're saying, please rely on the witness, the detective, to tell you what this audio is saying, right? But then it also puts an undue burden on the defendant, don't you agree? Because he doesn't have to take the stand, but now I'm having to rely on your witness to tell this jury what it is I said.
Correct, but I think the defense attorney actually took advantage of it, because if you mentioned, he pointed out at this time, didn't he say this? And he was actually able to use that to his advantage, because he was able to pull out the things that were important to him, and then he restated it. Whether or not that's what the audio actually said, the jury doesn't know. So they're going off what the defense attorney says. So I think that he took a great advantage of the audio not being clear, because he says, at this time, isn't it true that Landon said that's the truth, and this is what it is? And the detective agreed with him. So he took advantage of the fact that the audio wasn't clear.
Okay, so an advantage advantage for the defense that the jury can't really make out what's being said. But the part that I had a problem with, Ben, was the detective on the stand says, you know, they're listening to the audio, and then the prosecutor interjects and says, you know, what did, you know, the defendant say at this point? And he said, you know, he put his head down and said something to the effect of,
The only thing I'm guilty
the
of.
only thing I'm guilty of is not reporting. How in the world am I supposed to believe, as a juror, and we're only listening to audio, this isn't video, that the defendant put his head down at that time? Like, it's just odd that you can remember that, and we're 2 years in.
We don't know whether or not he recorded it in his incident report or any sort of report that he made subsequently. If he did not put that in there, and the defense attorney did not take advantage of that on cross-examination to record that really crucial statement that was in his incident report, he really missed an opportunity there.
I agree.
Yeah.
Okay, so what do y'all think the reasonable doubt is? The obvious is the cause of death, right?
I think that there's a lot of doubt so far, and I would hope that the defense, their witness, is really going to poke holes into the causation, because I think that's the main thing that we have here. But in the cross-examination of the detective, I think the defense attorney actually did a good job in making Terrell seem believable, in that he was cooperative. He said he fell. He brought up the fact that he mentioned the chest injury before he actually even knew there was a chest injury. He adamantly denied that he ever punched him in the face. So I think that there's doubt. Terrell in the video, from what we could see, seemed believable. So I think that there's definitely doubt that the defense can hang on.
Okay. Ben, you want to add something real quick?
I think that there's a larger issue than even causation. It's a question as to whether or not he even actually hit the man. I think that's a huge issue.
So where's the admission, right? I think we were all asking that
see
important
that,
question.
yeah.
Okay, so we're going to talk more after this quick break, guys. So you guys aren't going anywhere. So stay with us. We've got to take another break. Of course, we're still covering Georgia versus Terrell and keeping an eye out in Florida in the Nelson trial, where a verdict could come at any time. The jury's been deliberating now for 9 hours and 25 minutes. And of course, that jury question that the attorneys and the judge are trying to address at this very moment. So we're going to try to get you up to speed as soon as we come back. Stay tuned to CourtTV.
Morning, Detective Britton was on the stand again, continuing direct and cross-examination. We heard about a 40-minute audio recording from the defendant taken immediately after he did the video reenactment we saw yesterday. And again, the defense cross-examined for quite a while on all three of those audio and video recordings. And now the state is about to rest, Jodie.
Okay, I'm seeing that the judge is on the bench right now, so she's addressing the attorneys and the scheduling moving forward. So, Chanley, I'm going to take the viewers back inside.
July records that came, and so I'm going to tender those as a defense exhibit. The state doesn't have an objection. What I plan on doing is maybe when they come back in, if it'd be okay, I'll just move to tender it. I'm not going to object. I mean, it's sort of out of order, but if he's okay with it, I just don't want to forget. I can do it tomorrow. I just don't want to forget.
Okay. So I'll just bring in the jurors and then excuse them until tomorrow morning at 9 o'clock. And I think that's all we need to do with the jurors. Okay. All right.
Okay, so the judge there just addressed the defense attorneys, and they are going to resume testimony tomorrow, so she's going to excuse the jurors. Let me go back to Chanley, who is on scene right now. Okay, so Chanley, you heard what the judge said. She's excusing the jury until tomorrow morning. Who can we expect the defense to call tomorrow?
Well, the defense gave notice of its own expert in forensic pathology. In fact, that's probably why he can't testify until tomorrow morning. He is traveling into town to testify on behalf of the defense. He's an expert in forensic pathology who examined the injuries of Bennett. He did not do an actual autopsy, but he did examine the injuries. He might have a different cause or manner of death or opinion on what happened to Mr. Bennett. And then also in pretrial motions, this expert can testify about the credibility of the police investigation, according to the defense attorney. So we might hear some testimony about, kind of like what we heard on cross-examination this morning, about maybe what the detectives didn't look at or didn't do in their investigation against Landon Terrell.
All right, Chanley. So What about the gallery? We haven't really talked much about that. I've noticed that there's some people in the room. Do you know who they are? Are they family members or friends of Landon Terrell?
There's a lot of support for both sides in the gallery, Yodi. We have the family of the defendant, Landon Terrell. In fact, his wife is here today for the first time this week. His mother, his brother, his cousin, his church family, a handful, probably around 10 people sitting on the side for the defense right behind that table. And then on the opposite aisle, the victim's family. His 3 kids have been here the entire week, as well as a grandchild was here yesterday in support of Adam Bennett, the 91-year-old victim in this case. And it's a pretty full gallery. I'm sure you can see it on the cameras in here, but it's been a mutual thing. The very first day I noticed was the families shook hands, and they've gone their separate ways, but they've acknowledged each other in the courtroom. I think it was a really profound moment to have that sort of mutual respect as this trial determines the outcome.
Chanley, really quickly too, do we know, is there any chance maybe that Landon Terrell could take the stand?
There is a chance. I know that his attorney, right at the recess, went back into where the defendants are held in the holding cell to speak to his client once more about the possibility of testifying in his own defense. And the judge even indicated that maybe after the recess or after the jury is gone, if they want to look at jury instructions or if they want to go ahead and put on the record whether or not he's going to testify, that might happen this afternoon or first thing in the morning.
All right, Chanley Painter, thank you so much for that update. All right, I still have my legal panel with me, and I want to bring them in really quick. Okay, guys, so he may or may not testify, right? But we know that we've heard from him on several occasions, right? And his defense attorney has made it clear that he's been super cooperative, volunteering to talk to law enforcement. And there was one particular video that the jury listened to and watched, and that was Landon Terrell giving this reenactment to law enforcement that I do want to play for the viewers if they've missed it.
So then he falls, and
he proceeds to fall, and then I catch him.
you catch him.
Yes.
You stop him from hitting the floor.
Yes.
Okay. He's a big guy,
He is a big guy.
but you have no problem stopping him from hitting the floor. Okay. Then what happened?
And I proceed to lift him up. That's when he turned and hit his chest.
All right. Was everything here when that happened?
Right here?
Yeah. Is that there?
Yes.
Was the nightstand there?
Yes, everything was right there.
Okay. So where was his head in regards to the nightstand?
His head was not that far from here. I feel like it was a good distance where his head was.
Okay, now we got that transcribed. The jury didn't get the benefit of understanding what he was saying in that video. So from that short clip, did you get anything from that that might have been helpful for the defense?
I think Terrell seems believable.
He does.
He's describing what happened.
Yeah.
I think that, the way that the state made it appear in their opening was that this was a man who punched this 91-year-old, and seeing him speak and describing what happened,
Yeah.
I don't think that he has to testify. I think I said that before. I don't think that Terrell needs to testify because his testimony is on video. His testimony is on audio, even though the audio wasn't clear, but his attorney was able to point out the important things that he said. I didn't hit him. I caught him. He hit his chest. So I don't think that he needs to testify because that video actually helps the defense.
And Ben, where is this, again, this admission that he hit him in the stomach? Because the whole time we were talking, we were saying that was terrible. Why in the world would you ever hit a 91-year-old man? And so I'm still waiting for the state to witness, and they're expected to rest today. Who is the witness that you're going to bring to that stand to tell this jury that that's what he said?
If you are the defendant, you absolutely are going to hammer home in your closing argument. They promised you that he admitted to hitting this man. You never heard that evidence. In fact, you heard from Ms. Terrell in the course of that video tell you exactly how it is it happened.
Ben, I got to interrupt you. I'm sorry. We got to get people back into court right now. The judge is going to be asking Terrell if he's going to be testifying.
That no one can make or compel you to testify. That is, do you understand that you have a right to not testify if you do not want to?
Yes, I do.
Do you understand that not your lawyer, but you personally are the one who decides whether you will testify or not?
Yes, I do.
Do you understand if you do not testify, then upon proper request by you, the court will instruct the jury that your decision cannot be used against you. Do you understand that, sir?
Yes, sir. Ma'am, sir.
Do you understand if you choose to testify, you will be both examined by your lawyer and cross-examined by the assistant district attorney? Do you understand that, sir?
Yes, ma'am.
Do you personally want to testify or not?
No, Your Honor.
All right. I find that the defendant has made his decision to not testify with a complete understanding of his rights. Anything else to add to that?
Nothing from the defense, Your Honor.
Okay, all right. I believe we got a verdict form, maybe. Do y'all have those?
Judge, I have a copy. It was left on the table for me this morning. It looks fine to me.
Yeah, I got a copy as well, and I think I got it. I have it somewhere, but it looked fine to
Okay.
me. I mean,
You can look at it again.
yeah,
but
I mean, it was very, I mean, that's kind of what I thought it would look like, so. I'm not aware of any lessers I could even
Okay.
charge on that. But
All
I
right.
think, I'll provide, I don't know which email, I think it's all been updated, but my email slightly changed. I had to add an H, so I just circled that. Okay. If there's any, the other one is supposed to come to me, but sometimes it doesn't, I don't think.
Okay, thank you for that. And on the elder abuse and elder neglect charges, we're just going to use the statute for that.
Yes, ma'am.
Y'all
And
have-
and I think that's what I drafted up, and I think that's maybe what Jason would do, but I tried to take out some words that didn't
Yeah.
fit the case
Uh-huh.
quite. So that might be the only area where we might have objections or argument, I don't know.
I mean, I'll look at what he put together. I
Okay.
think he put a separate charge for them. I think I've included them in the felony murder count as the definition there, but used from the statute. And I'm sure what he put together will be fine, but we'll look at it.
Okay,
Other than that, I think everything else is packed.
okay, all right, yeah. We thought so too, so we'll try to get that to go around 4. Anything else that you want to bring up right now?
Nothing.
No, Judge, but I will also say, it's my understanding your witness is going to be on the road at 3 or 3:30.
Yes.
Okay,
The
we-
text I got said he'll be on the way at 3:30.
I would be my intent to try and call him. Obviously, he'll probably be on the road, but I will call him probably this afternoon and talk to him while he's on the drive, if you'll let him know.
I'll try and call him, because I was gonna do the same thing, so we might overlap, but I'll let him know.
If that doesn't happen, I'll let you know in the morning, Judge, but
Yeah.
since we just got his report Monday morning, and I haven't had the opportunity to really talk with him about his testimony.
And I'll give you time, and if you haven't had time to talk to him, I'll work with you and let you have time to interview him in the morning or talk
Yes,
to
ma'am.
him prior to,
And he did text me that he hadn't heard from you, so it's not like he won't, he'll definitely answer the phone.
Been a little busy.
Yeah, just a little bit.
Thank you, Judge.
All right, thank you. All right, if we have a problem with the charge, we'll let you know, but we should get it to you this afternoon then.
Thank you.
Thank you,
Okay.
Judge.
Do you need this?
And Trinity's printing a red line version out.
Okay, okay.
All right, so you heard the judge there. They were trying to hammer out scheduling issues. The defense witness tomorrow is going to be driving into town, and so they're going to basically call a recess for the rest of the afternoon. And of course, we still are watching verdicts in the Scott Nelson trial in Florida. So we're covering both trials for you. We're going to definitely get you up to date, but we've got to get a quick break in. So don't go too far. Stay with Court TV Live. Welcome back to Court TV. All right, so the judge has called a recess in the Georgia case, the Georgia versus Landon Terrell. But I need to go to the legal correspondent, our legal correspondent, Chanley Painter, who's still outside of the courthouse. Chanley, I have a million questions. One question in particular that's super important. The state rested today, but I have yet to hear a witness from the state that said that Landon Terrell punched Adam Bennett in the torso. I have not heard that yet.
We heard it from Adam Bennett, who told a couple of caretakers that he was hit in the head, the chest, and the abdomen. But you're correct, we didn't hear it directly from the defendant, unlike what the arrest warrant said in the court file when he was arrested, that it says he admitted to striking the 91-year-old And so I was very much listening, and I didn't hear it in the opening statement, and I have not heard any witnesses. And now, while the audio was very, very difficult to hear yesterday and today in the courtroom, in fact, the jury sent a note during the audio today saying, we can't hear what's being said. The prosecutor apologized, said this is the best we can do. So after court recessed, I ran into the detective who was on the stand, and I asked him, because I was wondering the same thing, Yodit, and he said that at the beginning of that audio, when Landon Terrell says that he hit him in the chest, and this is while Landon was describing how he caught Mr. Bennett from falling and lifted him back on the bed, that he hit him in the chest. The detective said he interpreted that statement as saying that he actually hit him, punched him in the chest, and that's what he used when he wrote that arrest warrant.
So the arrest warrant stated that Landon Terrell admitted to hitting Adam Bennett, but what you're saying is you clarified this with the detective when he was finished testifying, and he's saying this was all his interpretation. Correct? Am I hearing that right?
Yes, you are correct. You are correct. That's what he told me.
Wow, that's a game changer. I mean, obviously we thought that there was an admission. I'm trying to hear this admission over the past several days. I have not heard that admission. In fact, I'm hearing the entire time that Terrell is being consistent with saying, I did not hit him. And so it's just, it's just all confusing, but this is raising enough doubt. You're a lawyer, this is problematic for the state who just rested. Okay,
Yes.
Well, Chanley, tell our viewers what we can expect moving forward. So the judge has called a recess for today, so tomorrow, what do we have coming up?
Well, tomorrow we can expect the defense to start with their own expert. He's an expert traveling in from out of state today, and he's a forensic pathologist. So he examined the reports, medical reports and injuries and photos of Adam Bennett. So we can expect that maybe he reaches a different conclusion than the county medical examiner testified to yesterday. Is it possible that this was to the fall? And what Adam Bennett did, according to Landon Terrell. Now, we did just learn that the defendant will not testify just moments ago, so we probably can expect just that one witness before the defense rests.
All right, Chanley Painter, thank you so much for that update. All right, back with me now are criminal defense attorneys Chinwe Foster and Ben Sessions. All right, so y'all just heard that, and we're just hearing this for the first time, right? This entire time we're thinking, based on an arrest warrant, right? Laying out the probable cause for someone's arrest, that he admitted to hurting Adam Bennett, and we didn't hear that admission at all. Chinwe.
I am blown away that the defense attorney did not cross the detective on his warrant and make the office. And this is what upsets me so much about police reports, because police reports are based a lot of times on the officer's interpretation.
Right.
And a lot of times people look at a police report and they see it and they say, well, that's what happened. But no, the defense attorney really should have crossed the detective. When you took out a warrant that said that he admitted to hitting Mr. Bennett, and he never did.
Yeah.
And that was really a missed opportunity. And that's the first time that we heard that, and I am shocked that that wasn't brought up in front of the jurors.
In fact, I can't recall who the actual witness was, Ben, but the defense attorney had the detective or a police officer, it was a police officer, admit that his report had an error in it. So you would think that this defense attorney would say, okay, hold on. You are the one that issued this arrest warrant. In the arrest warrant, there's information about my client admitting to something that we haven't heard yet. Is that not wrong? Is that not incorrect? Why didn't he do that?
You've absolutely got to key in on these inconsistencies. And the reason why it's really important is because you heard him give opinions in the course of his testimony about, hey,
he wasn't qualified to even make, but yes.
Correct. That Ms. Terrell gave an account that he thought was inconsistent based on the evidence, based on his interpretation. You then point out that you also interpreted this statement to be an admission to hitting him, and we have never once heard that. Whenever you then show those inconsistencies between the evidence, the way that he interpreted things to be incorrect, and you show that to a jury, you directly call into question his credibility, and that's exactly what he needs to do.
It's infuriating, y'all. I mean, look, this is a sad case. Obviously, a 91-year-old man, a war vet, died, right? But you also have someone who is fighting for their life as well. So you have a man who has been in jail for 2 years, denied bond, and now we're having to hear that this arrest warrant is incorrect. You're having to really understand that the state didn't have much to go on. In fact, I think that he's being overcharged. Shinwei, what do you think? You practice in that county, in this state, in this city. What do you think?
I absolutely think that he was overcharged. Looking at the felony murder under the elder neglect, the state, I believe, is going to use the fact that Landon said, well, the only thing I may be guilty of is that I didn't report it. Felony murder, you have to show that the underlying felony, that there was the death was foreseeable.
Yeah.
Elder neglect, the state is reaching, and I'm just shocked at this whole thing. One, the fact that he's been in jail for 2 years with no bond. One, that you took out a warrant for murder, and you made such a egregious error, and this man's life, Terrell, is now, hanging in the balance because I'm so upset. I can't even speak. I'm
Ben,
so
your
upset.
thoughts about being overcharged?
I completely agree that it was overcharged in terms of the interpretation of the physical abuse that they alleged. The neglect bothers me, and I'm really fearful for Mr. Terrell in that regard because of the statement that the only thing I'm guilty of is the failure to report it. The neglect being there that, hey, if I had in fact taken the steps to let them know that the man had fallen, that he had injured himself or potentially injured himself, maybe then they prevent the death if it was reported earlier.
Yeah.
But I still think we've got a real problem here about whether or not that's actually a causation or substantial cause of the death for the jury to determine. I think most jurors look at that and go, look, if we don't know for a fact that this man actually struck this person, I believe they find him not guilty. I just don't think that they can show a cause of death here on that.
And also, I found that jurors in Georgia are really confused with felony murder. And it's going to be really important how, in the jury instructions, how it's defined. Because what the state is going to make it appear is that if you find him guilty of this felony and that the death was a cause of the felony, then you have to find him guilty of felony murder. But there's a lot more to it. There's case law that talks about, there's no intent in felony murder. You just have to prove the fact that the underlying felony occurred. But the death causation, it has to be foreseeable that him neglecting to report this injury caused the death.
Right.
And it's just not there. But the jurors sometimes are confused on that definition of felony murder. So I hope that the judge makes it clear.
So what do you think about the defense now wanting to call this pathologist in that is going to obviously say the opposite of the state's medical examiner, but he didn't examine Adam Bennett's body? Ben?
That's a huge problem that they're going to have with him, the inadequacy of his investigation. See, on the one hand, he's going to come in and say the state's experts didn't do X, Y, and Z. But then they get to come right back on cross, the state does, and say, hold on. You'd agree the very most important thing that you can do is actually observe the body yourself. And he's going to have to concede that, and that's going to be a problem with his credibility in turn. I don't like them fighting over necessarily the cause of death, so to speak, and trying to link it up to whether or not his hit allegedly caused the death. I think the defendant probably needs to take the position that I didn't even hit him at all. They thought that I struck this man physically with my fist. I was trying to catch him, and that's the only account that he's ever given. On the neglect account, that's really where they're fighting over causation. That I failed to report this, and then therefore it caused the death. That's their defense on it. That charge is really weak, though.
It is, and I'm going to definitely get you guys to give me more of your thoughts on Georgia versus Terrell when we come back, because I got to get a quick break in. And we also have an update from Florida when we come back, so you don't want to miss that. Stay with CourtTV. Welcome back to CourtTV. There's been a note from the jury in Florida versus Scott and Nelson this morning. Let's head straight to the Orange County Courthouse in Florida and check in with our crime and justice reporter, Julia Janae. Julia, tell us more about this note that was sent and what the judge plans to do about it.
Yodit, this jury wants more information. They have asked for a readback of the testimony from Dr. Gregory Pritchard and Dr. Valerie McLean, those two dueling psychologists for the state and for the defense, but they only want the references to PTSD and bipolar disorder. So right now the court is trying to figure out what that's going to look like. The court reporter is going to go through the transcript, pull up with a word search all of those references that those two psychologists made to those two conditions. And then the two attorneys on either side, they want to make sure that whatever is selected is in context. Because if you just pick out one sentence that has the word PTSD in it, they fear that it might not give the jurors enough of information about what that question was about. So there's a little bit of work that's going to take place before these jurors can get a response to that question. So right now they've been told to wait, and the judge is going to reconvene everybody at about 11:30 to decide how do we go forward, what can we give them, and work through this issue for the jury.
Now, Julia, I might have missed this point. You might have already said it, so excuse me if you did. The jury just wants to know about PTSD and bipolar given from the mental health experts just from the defense?
No, from the state and the defense.
Okay.
So on Monday we heard from Valerie McLean. She was the defense expert, and Dr. Gregory Pritchard, he's the state's expert.
That's going to be a lot of testimony. So they're obviously going to be combing through their record, and there's going to be a readback at some point. I know you said something about 30 minutes, or it's going to take some time, or I heard the judge say that in court.
Right. The judge wants them to come back, meaning the two parties, Scott Nelson and the court reporters, and they will first talk about what the readback is going to look like. Because before they go before the jury, they want to make sure that everything is fair, that the statements are in context, and there'll be some agreement that they have to come to in case there's more information that the defense wants to share with the jury. And if the state objects, then there may be some back and forth. So it might be a while before this jury gets that readback, and we're already getting close to the lunch hour.
All right, Julia, thank you so much. We're going to be checking back with you soon. Turning back to the trial of Georgia versus Landon Terrell now. My legal panel is still with me, Chinwe Foster and Ben Sessions. All right, guys, so a lot of frustration. I know you guys wanted to say so much more. Chinwe, I think I cut you off before the last break. What, again, are your thoughts on where we're at? The defense is going to be calling their first witness tomorrow. Who else should they be calling?
They should definitely be, even though there's no burden on the defense.
There's no burden,
But
absolutely.
you have to take the opportunity where it's there.
Yeah.
And I think that they missed the opportunity, or calling some kind of expert on dementia to explain why Mr. Bennett may have said he hit me, to explain why Mr. Bennett's behavior may have gotten more erratic, to explain why Mr. Bennett could have called his daughter saying, I'm dying. So I think that if they don't call an expert witness on dementia, which doesn't appear that they are, that's definitely a missed opportunity.
Okay, so Ben, you had mentioned that you were surprised that the state didn't call an expert to talk about that. But don't you think that that would have been a bad thing for the state to do?
Absolutely, it would have been.
So
Yeah,
it's not a surprise that they didn't call someone?
It's not at all.
Okay.
No, we don't know what the jurors said during jury selection about their prior experiences with dementia. I hope at some point in time that idea or that concept has been introduced to jurors, that, hey, have you had some sort of prior experience with people with mental deficiencies later in life,
right,
dementia, that sort of thing, and had difficulty recalling events accurately? You may very well have jurors on the panel that are equipped to go back in the room and say, look, this kind of thing happens with someone who has got dementia. We don't know what the scope of those conversations were during jury selection, but the defendant unquestionably should have put forward some evidence in that regard if you don't have jurors that are going to make that argument for you.
And it should definitely be referenced if the defense doesn't want to call an expert to talk about that. Most certainly want to bring that up in closing. Absolutely. And say, this is the reason why. Did y'all know that this is an individual who suffered from this, and this is why the state didn't want to bring this information to you in the first place, right?
Definitely.
But if you don't have that, don't have any testimony on it, you're inevitably going to draw objections from the state that, Judge, those are facts that are not in evidence. You didn't have anyone someone who testified that this is the kind of thing that would be inaccurately recalled by a person who has that kind of problem.
Well, you think that the defense would have that information, given the fact that I think it was the defense exhibit number 1, and he showed this, the defense attorney showed this to the detective on the stand today, and it was the discharge of Adam Bennett from a previous home, right? So you would think that you would have the history of what he suffered from. He obviously needed more care. Why is the jury not thinking about what it is he suffers from?
Exactly.
Besides being old.
Yep.
But let me get your thoughts on this one quick clip that I want to play, and I'm going to get your ideas and your thoughts and your opinions on this. But this was the first interview that was done with detectives and Landon Terrell, and I want to get your thoughts on that, okay?
What happened was Mr. Bennett, right?
Yes.
Mr. Bennett, sometimes when I was working on him, sometimes he got to take his pen off. All of a sudden, I changed him. And I didn't want nobody to smell like pee and poop all day. So all of a sudden, when I changed him, he was like fighting me. I had his body close to the bed like this. Turned him over. That's when he was like twisting his body, turning up, kind of like hurting all over. So then I tried to go back, turn him over again. I nearly dropped him.
Alright, so at 2 o'clock you had to change that as the pin?
I had to change him again. He was full of pee.
Okay.
I had to change him again. After I had him situated, he just kept on like putting it on. I had to put like an extra pen over the pen I already had on him.
Right.
He kept on ripping it off.
Was he saying anything?
He was like, don't let me fall, like you're not gonna fall.
That is very telling. That the end there of that video, that interview, he's saying that one, it's no surprise. I mean, there was another witness from the state who testified that, Mr. Bennett was sometimes a little combative and didn't understand instructions really well. So you have a man who obviously is afraid to fall because he has a history of falling. And you hear Landon in that interview telling the detective that he was telling him, don't hit me, please don't hurt me, and please, don't let me fall. Mm-hmm. So how is that helpful for the defense? I mean, I think it is, and I'm going to refrain from saying why, and I'm going to let you do it.
I mean, I agree.
Unless you don't agree.
Well, no, I agree.
Okay.
And I think that it kind of goes to what we're talking about dementia. This is a man that is creating or maybe creating things that may have happened. And I think that the state, they're going to hang on to the fact of a technical dying declaration where Mr. Bennett says, he hit me, I'm dying. But you see that he is someone who, I don't want to say makes things up, but the dementia makes him see things that maybe aren't there.
Yeah, Ben.
It's going to be really hard for a juror to really give real credence to that man's statements. I mean, this is the same, I don't mean to belittle this man's life.
No.
But at that point in time, he was a person who had walked out to a public area, pulled his pants off, and defecated in that area.
Yeah.
I mean, that's who they're relying upon in saying, I can tell you that the story that he's telling me is accurate and reliable. That's what their case is dependent upon. And you can't put faith in that type of...
You can't, and honestly, look, what are those dates again where Adam Bennett fell multiple times? We're talking, okay, so the alleged incident was August 15th. He had fallen on June 28th, June 30th, July 1st or July 2nd, and I believe one other time, August 9th. How do we know he didn't sustain any injuries that went undetected until one day he really started to feel the pain? How do we know? We don't know.
We don't know. We absolutely don't know. And it mentions that those other times that he fell, he had bruises even on his face.
Yeah, and who knows internally is my point too.
Exactly. So hopefully the defense brings that up in their closing.
You know what's unfair too, and I know that this was probably already hashed out in civil court, but this facility has had issues like this before and have settled many times before with respect to how a client or a patient has been treated in the facility. And so you have this individual too here who has a history of falling and then you have this facility who's known to understaff. So it was more likely that he's probably, you know, not in the best supervision there at that. And it's crazy because he left one home to get more care and ended up at this facility and they were understaffed.
We were talking about this earlier. I think that the state would have done far more good for the community if they had been able to criminally charge the actual facility itself.
But who? Who would pay for that?
Officers, shareholders of that company that would be criminally liable as a result of the horrible conditions they allowed to exist there. You allowed, this man was the only male that was on staff that night.
Caring for how many people? I think, what, 20?
20 people, yeah.
20 by himself.
And if you're looking at the injuries that are there, for example, broken ribs, it's so easy for a person to have broken ribs at that age and for it to be undetected. And you can't do anything really to treat it except for just to allow it just to heal on its own. So, I mean, that's the type of injury that there's no way that they can reasonably say that it was caused that night or particularly by Mr. Terrell.
Okay, so here's an issue that I want you guys to think about. So we know that the state is going to, they have rested, and they're not going to present any more evidence. But do you think that a directed verdict is appropriate in this moment?
I mean, of course, the defense is going to ask for it, but I think that there's enough to send it to the jury. One, you have Mr. Bennett's statement, and it's up to the jury to determine whether or not they want to believe that. You also have Mr. Terrell's statement where he said the only thing that I could be guilty of would be not calling. So that's the elder abuse and the elder neglect. And I think for directed verdict, there has to be really no jury question. But I think that here we have enough where it could go to a jury for the jury to make the determination.
Ben, the issue of directed verdict? And again, for our viewers who may not know what that is, but that's basically the defense would be asking the judge to find that the state did not prove their burden and without having them put on any evidence. They don't have to, but at this moment, after they've rested, judge, please understand that the state has failed to meet their burden beyond a reasonable doubt to prove this murder occurred by my client and toss this case, dismiss this case, acquit him.
I truly, I don't believe this guy should stand convicted of these charges. Crazy things happen in the course of jury trials. I wish that it was a reasonable probability that he'd get a directed verdict on it.
Yeah.
I think it would be the right thing based on the way that he handled himself. It's never going to happen.
It's not going to happen. And you know the judge, right? You've practiced before.
It's just not going to happen on virtually 99% of Superior Court judges in the state of Georgia. You're just not going to get a directed verdict on this kind of case.
All right, Chinwe Foster, Ben Sessions, thank you so much.
Thank you.
Thank you.
All right, guys, so we're covering two cases.